And this matter comes before the court this afternoon on defendant's motion for summary disposition pursuant to 2.116C8 and the terms of Michigan's Dram Shop Act. I would invite counsel to place your appearances on the record.
Good afternoon, Your Honor. Brandon Wolf on behalf of the plaintiff.
Thank you.
Good afternoon, Your Honor. Richard Karen appearing on behalf of the defendant.
Very good. Thank you, Mr. Karen. And I have received and read the briefing, although admittedly I read it a couple weeks ago because this has been rescheduled. Since it's your motion, Mr. Karen, I'll let you update me with anything you feel is critically important. It's a C8 motion, so obviously it's limited simply to the four corners of the complaint. And I take it that you're saying, Judge, as written in the complaint, all of these must only fall under the Dram Shop Act. There's no development under the complaint itself that could take it outside of that. Is that fair?
That's pretty much it, Judge. I'm saying that even if we admit that this young man was allowed to consume alcohol to excess and after hours and all that, which we vehemently deny, that there was a culture of that at the pub. When he left the establishment after becoming intoxicated and got in the single car accident and killed himself, the only viable argument there is that he was injured as a result of the provision of alcohol to him. Plaintiff cites some cases where you can allege something in addition to a violation of the Dram Shop Act, but that's generally, Your Honor, when there's a bar fight and the bar owners or the employees are on notice that there's going to be a fight, that there's already been some words or some altercation, and they fail to take their duty, which is to involve the police, and that because they fail to undertake their separate duty to keep their patrons safe, that the fight ensues. But that's clearly distinguishable from this kind of case.
The courtroom opens in a calm, procedural tone, but beneath that surface, something heavier is already brewing. A motion for summary disposition is on the table. In simple terms, one side is asking the judge to throw the entire case out before it even reaches trial. Right from the start, the energy is controlled, formal, but tense. Both attorneys step in and place themselves on record. The judge acknowledges the briefing but makes one thing clear: he's already read the case, and now he wants to hear what truly matters. The defense wastes no time. Their position is sharp, almost surgical. Everything in this complaint, every claim, every angle, leads back to one thing: the Dram Shop Act. In their view, there is no escape route, no hidden legal doorway. If alcohol is the cause, then the law already has its answer. But what makes this opening moment powerful is not just the argument, it's the framing. Because from the very beginning, the judge is being guided toward a single question: is this just an alcohol case or something more? And in that question alone, the entire future of the lawsuit hangs in balance. The stage is set. The legal trap is already forming. And neither side has even realized how narrow the path forward is about to become.
Case where had there not been the provision of alcohol, there would have been no accident.
I think the case cited by both parties that comes closest here is the Majeski case, and my recollection is that involves like a topless dancer, and her allegation is, well, I'm underage, so obviously I, shouldn't be served alcohol by anyone here, but part of this bar's policy was to allow, the customers at the bar to ply me with alcohol, perhaps in hopes of getting, who knows what, nothing good. And that's what caused. And then she goes out. My recollection is, I think she goes out and is in a fatal accident after that. So, how's that distinguishable?
In that case, they did not say, the court did not say that there was a separate action there. It said that they were remanding it for the court to determine whether the improper training, etc., was something separate and distinct that had its own common law recognized duty that did not essentially involve the sale of alcohol. And so they didn't say that the exclusive remedy does not apply in that case. They just say we need some more information. And it's a very similar case, although in this case, again, it's not other people purchasing alcohol for the young dancer. It's a man who was
Apparently
being
is of
served.
legal age here, and he's perhaps just drinking off the bar supply himself and gets himself into this situation. There's not indication that the management's encouraging him to drink extra. I mean, I think the allegations the management allows or encourages this conduct by staff, perhaps to retain their employees. Hey, stay an extra hour after the bar closes and drink all you want. That's just a benefit of employment. I think that's as close as we can get.
I think so. However, even if we did do all that, it's still it's still solely is involved in this accident because of the alleged provision of alcohol. And I think if we were to allow a separate cause of action on this and that the exclusive remedy provision would not apply, then we would be negating that provision, which the legislature clearly thought was appropriate.
Yeah, and
And,
the
and
courts have said provides in effect, one size fits all or one-stop shopping in a case involving a dram shop. So I'm in agreement with you. It's intended to be a comprehensive scheme, and obviously there are some things that could bring it outside. And you're saying just, Judge, when you read the four corners of the pleadings, those aren't here.
there's no separate and distinct duty recognized by common law that did not involve the provision of alcohol. Thank you.
Very good. Thank you. Let me hear from Mr. Wolf.
Judge, thank you. Obviously, we see it much differently. And I think this is not a one drink too many serving case. This is about
Now the defense begins tightening the noose. Their argument becomes more structured, more confident, almost as if the outcome is already obvious. Even if the allegations are taken at face value, excessive drinking, after-hours consumption, even a toxic bar environment, the defense insists it all collapses into a single legal category, dram shop liability. They draw a sharp line in the courtroom. Other cases, like bar fights or failure to intervene, are brought up only to distinguish them. In those situations, they argue, there might be separate duties, like calling the police or preventing violence. But here, there is no external incident, no independent harm, just alcohol and what happens after it is consumed. Then comes the reference to prior case law, Majeski, a case where the court had to examine whether something beyond alcohol service could create a separate legal duty. The defense leans on it carefully, arguing even that precedent does not open the door the plaintiff wants. Their message is simple but powerful. If the injury begins and ends with alcohol consumption, then the Dram Shop Act is not just relevant, it is exclusive. And with that, they attempt to close every possible alternative argument before it can even breathe.
in a culture that they've kind of, allowed these employees to get drunk in excess. It's about encouraging employee intoxication, drug use on the property. There have been people that have died apparently and have sued the bar in the past. Their liquor license apparently has been revoked or suspended. So this isn't just about this isolated occurrence. It's about everything else. It's about this workplace culture. Just because it involves the sale of alcohol on this one occasion doesn't mean it can, destroy every other conceivable or cognizable legal claim, against the bar. It's
Well,
about
no, but against when it's because I mean I don't think there's any dispute here that your client here in the situation is the alleged intoxicated person. I mean he's the person. It's not as if he went out and hurt someone else. He went out and hurt himself. And I'm not reading anything in the complaint that says it was a combination of drinking and the fact that this place was also an after hours warehouse of illegal drugs, and that created a impairing cocktail for him. I just didn't see that pled in the complaint. I mean, it seems like he was drunk It was alcohol, and he left the premises. And I get it, right? I'm certainly not sanctioning the management practice here in doing so, but I do think that this is the kind of case, if that's what there is to it, that would fall under the Dram Shop Act because it's alcohol. And I guess the way I determined that is I looked at each claim in your complaint and I said, well, could you add on the term because of alcohol? And the answer was yes. So how do we get out of that, if at all?
I think it goes to the negligent supervision and in the training of this employee, whether or not he was trained to be responsible behind the bar under their direction. And I think that's what it is. It's this unique duty between an employer and an employee, and that derives from control and it flows from control. They are responsible for training these people to not drink in excess, to not serve in excess. There was no training here. And it's much broader than, well, yes, he drank alcohol and he got behind the wheel. And no, this is the workplace culture. This is the environment that they fostered. And I think it's very foreseeable that when you have an environment like that, that somebody either is going to be killed or will be killed themselves. They're going to kill somebody or they're going to kill themselves. And that's exactly what happened here. I
Well,
just
and the
think as
person that gets killed has, frankly, a much better cause of action than the person who is themselves intoxicated and then is the decedent in that case. Because, right, obviously the innocent third party out there shouldn't be victimized by the improper culture, but when a person is in it, participating in it, well, and I mean, I think what you're saying is, Judge, over and above Dram Shop, this place, this is Dram Shop Plus. I mean, they're not just, over serving a patron at the bar. They're whipping up this culture where every employee stays at the bar and they encourage drinking to excess, and they're not providing, hey, here we got a PBT by the door, maybe you ought to check yourself or whatever. They're just sending people out the door to, knowingly to endanger theirs and other people's lives. And Judge, Dram Shop, as comprehensive it is, doesn't encompass that.
that's correct, Your Honor. And I think it warrants further fact development. The Majeski case is right on point, and that was on C10. This is based on the pleadings. So at the very least, I think it warrants further fact development. Now, if it's not there and, there's no evidence to support whatever we pled, then it's appropriate for dismissal on C10. But based on what I've learned from people already, that this was a culture that was foreseeable.
This is where the energy shifts. The plaintiff pushes back hard, and instead of focusing on a single incident, they expand the battlefield. According to them, this is not just a one night of drinking gone wrong situation. It is something deeper, more systemic, a workplace culture where excessive drinking wasn't just tolerated, but allegedly encouraged. They paint a picture of a bar environment where employees are not restrained, but normalized into intoxication, where after-hours drinking isn't an accident. It's part of the system itself. The plaintiff escalates further, referencing past incidents, even suggesting prior deaths and licensing issues. The implication is clear. This is not isolated behavior. It is a pattern. But the judge does not let that expansion go unchallenged. He cuts into the argument with precision. The key issue, he insists, is not whether bad culture exists, but whether the law recognizes a separate legal duty outside of alcohol provision. And here, the tension peaks. The plaintiff tries to stretch the theory further, arguing negligent supervision, negligent training, and employer control over employees in a dangerous environment. But every time the argument expands, it circles back to the same core problem. Alcohol is still the trigger point. The judge presses harder. The decedent himself is not an innocent third party. He is the person who consumed the alcohol and drove away. That distinction quietly shifts the entire weight of the argument. At this stage, it becomes less about emotion and more about legal structure. And the structure is not bending in the plaintiff's favor.
Well, somebody was about to get hurt and ultimately did.
May I respond, Your Honor?
Yeah, go ahead, briefly, Mr. Kim.
Sure. I've not come across any recognized common law about a culture at a bar, and whether it's a person behind the bar or a waitress or a patron sitting at the bar, there's no difference. It's all what was a service of alcohol made to a minor that contributed to the accident or to a visibly intoxicated person. There's no separate and distinct duty apart from what Your Honor said earlier when you were analyzing the case.
All right. No, I think I understand both of the arguments. In a brief bounce back to Mr. Wolf here. Oftentimes in the C8 motion, the answer is, well, Judge, we could amend and we can fix the thing, but I haven't heard you argue that here, that there's some sort of amendment, that would be possible at this stage based on new information, additional. And I guess when I was thinking through as I analyzed the case, well, what could that amendment potentially look like? Well, if you learned that the bars provided the car and they knew the car had deficient steering and brakes, well, then, that would be an amended element of the complaint that not only were they negligent in maintaining the bar, but they were poor garage keepers or negligent garage keepers as well. But I don't see something like that forthcoming. Am I missing it?
I don't have that as an officer of the court, Judge. I can't tell you that here today that that's the case. Um, but
No,
I
that's
do,
fair.
yeah.
Yeah, I get it. Right. Sometimes it's there and sometimes it isn't. So I think I understand where you're coming from. Well, I have reviewed the pleadings and I've heard the arguments on this case. This is a motion, of course, under for summary disposition under 2.116 C8, which says that reading the complaint as it is, solely as pled, both giving any factual question, of course, the benefit of the doubt to the plaintiff, the non-moving party in the case, that no development could possibly justify a recovery. And I just listed, what would be a factual development I could think of? Well, something outside the realm of alcohol, that there was a vehicle that they did, or in the case of some of those cases I reviewed, well, instead of dying in a car accident, this guy falls down the improperly constructed steps to the basement and he breaks his neck and dies. Well, there's the negligent maintenance of the premises type case, but none of those appear to be present here, in that each element of plaintiff's complaint, and I'll go through that here and list them. That could, as I said earlier, and those are listed, I think, in the alleged breach of duties in count one, negligence, paragraph 22 or 23, counts A through L, allowing a whole different group of different claims here. And I took a look here and tried to see, which duties, and really the ones that I think are closest here are allowing these improper after-hours gatherings on the licensed premises that allowed consumption of alcohol beyond their legal hours or beyond their permit authority. Well, that clearly involves alcohol here, and that's K. And then I go back to J as negligent supervision and monitoring. By promptly cutting off service to employees, patrons exhibiting signs of visible intoxication. Well, it sounds like it's a scenario here where the owner of the Mervelous pub, allows his staff to stay there and get liquored up without much regard to who's drinking water, who's serving whom, and everyone forgets their dram shop and reasonable responsibilities because, hey, we're all employees here, and the rules don't apply in this. After hours scenario that's permitted and perhaps even encouraged by the bar owner, perhaps even participated in, who knows? But nonetheless, you could append because the use of alcohol there. It all involves the consumption of alcohol. There is some allegation that there was illegal drug use, that had occurred in the past in those gatherings as well. And perhaps it would be a little bit different if because in addition to this free for all of alcohol, there was in effect a bazaar or a buffet table of drugs lined up and openly chosen and used by the employees. And this guy, though, drinking an unknown quantity or perhaps not even having alcohol, decided to, shoot up with opium and mixed with fentanyl and all the other stuff that can make it into illegal street drugs, and then gets behind his wheel and crashes himself and kills himself. But none of those facts are pled. It appears to be the alcohol consumption led to the crash and the death, unfortunately, of plaintiff's decedent, putting him in the shoes of the alleged intoxicated person contemplated by the Dram Shop Act. And given all of that, I think that I agree with the defendant's brief that this inevitably then is going to come under the Dram Shop Act because, as it's been stated, by the Michigan Supreme Court, I believe that the Dram Shop Act was intended to be a comprehensive address of all misuse, overuse, misserving of alcohol on the premises. Now, can it cover every possible scenario that can occur on a premises that serve alcohol? Well, no, I've already identified a couple. The defective vehicle, the defective stairway, and for that matter, involving the underage dancer. One can only imagine the sexually abusive environment that perhaps prevails at an establishment like that. And obviously, I don't think anyone's going to say, well, there can only be Dram Shop, Judge, because the abuse was all brought on by drinking. In fact, I'm pretty confident there are probably people that don't drink and go in there and abuse the employees or contractors or whatever the women are employed as anyway. So I think that these, however, in this particular case, fact specific here, as pled in the complaint, all of the complaints alleged, all of those subsections alleging negligence, do fall under the Dram Shop Act, and thus I will dismiss plaintiff's complaint, except as it relates. Is there a section of it that is under the Dram Shop, or is it all under negligence? That's all under negligence. So
All under
it's
negligence,
just
Judge.
it is a dismissal of the plaintiff's complaint at this time under MCR 2.1168.
Thank you, Your Honor. Would
Understood.
you like me to provide the court an order?
That would be great, Mr. Karen, if you would submit it under the 7-day rule.
That would be great. Thank you.
Now the courtroom enters its final phase: analysis, breakdown, and closure. The judge begins testing the boundaries of the plaintiff's theory. He explores hypothetical scenarios: defective vehicles, unsafe premises, staircases collapsing, anything that could exist outside alcohol liability. But with each example, he is searching for something crucial, a claim that is truly independent of alcohol. He doesn't find it. Instead, he methodically returns to the complaint itself. Each allegation: negligent supervision, improper after-hours gatherings, failure to cut off service. All of it traces back to one central act: alcohol consumption. Even the more creative claims, like workplace negligence, cannot detach themselves from that foundation. The judge then makes the decisive move. Under Michigan's procedural rule for summary disposition, he evaluates the complaint strictly as pleaded and concludes that no legal development could transform these facts into something outside the Dram Shop Act. And just like that, the decision lands. The entire complaint is dismissed. No trial, no evidence stage, no expansion of facts. The court determines that everything alleged, no matter how it is framed, ultimately falls under a single statutory system already designed to handle it. The gavel doesn't just close a case here. It shuts down an entire legal theory before it can evolve. And the message is clear. In this courtroom, alcohol liability is not just part of the law. It defines the limits of every argument that enters it.